This is Bloomberg Law with June Grasso from Bloomberg Radio.
Hundreds demonstrated in Lower Manhattan again today to protest ICE agents arresting former Columbia graduate student Mahmud Khalil, an activist during last year's pro-Palestinian protests on campus. Khalil spoke for protesters after students stormed into an academic building last April.
This is a movement, an anti-war movement. We have sparked similar Gaza solidarity encampments across the nation and even across the globe.
Khalil is a legal permanent resident married to a U.S. citizen, and he's challenging his arrest, accusing the government of retaliating against him for his constitutionally protected advocacy on behalf of Palestinian human rights. White House Press Secretary Caroline Leavitt told reporters today that Secretary of State Marco Rubio has the authority to detain those who engage in behavior that goes against American interests.
Actually, it says right here, reasonable grounds to believe that the alien's presence or activities in the United States would have potentially serious adverse foreign policy consequences to the United States. And I think siding with Hamas makes that quite clear.
But a federal judge in New York City has blocked any attempt by the Trump administration to deport Khalil while the court considers his challenge. Joining me is immigration law expert Leon Fresco, a partner at Holland Knight, who is head of the Office of Immigration Litigation during the Obama administration. Leon, the facts of his activism are going to be very important here. Tell us a little about him.
The student's name is Mahmud Khalil, and he was a Columbia University student last year. He's not a student anymore, but he was an activist for the Palestinian cause in the university. And if you may recall from the previous year, there were a number of demonstrations at Columbia University that actually really were newsworthy, and you had politicians from both sides going and visiting the university and holding press conferences there. And so there was a time where the student was suspended from the university and then was reinstated. And thus there is quite a lot of developing facts in terms of trying to figure out exactly the level of culpability of what this particular student did or didn't do at Columbia University. And so that part is actually quite relevant to a lot of the legal issues about what the government can and can't do in this person's case.
Yeah, so apparently when they went to arrest him, Homeland Security said that they had an administrative warrant and that the State Department had revoked his student visa. But he has a green card, so he's not on a student visa.
Correct. So let's go through both aspects of things for a second. Normally, if someone has a student visa, the State Department can revoke the visa, and then what that means is that ICE can then come in and charge the person as being in the United States with a revoked visa and so place them in removal proceedings. But that's not what happened here because this person is a lawful permanent resident. So, unlike in the criminal court, where when someone gets indicted, that document, the indictment, can be read by the general public and seen. In the immigration court, there actually is a document that's very similar to an indictment called a notice to appear, but that document is confidential under the immigration law. The only way that the public can ever see that notice to appear would be if this individual, Mahmud Khalil, or his attorney would actually release it into the general public. And so that hasn't been done yet. And so we're speculating as to what would be the charge, because there actually has to be a charge in that document, the notice to appear, to, number one, detain Mr. Khalil. That would be the first point. But then number two, to actually remove him from the country. So there are two potential areas that people are targeting here. The first, because of what Secretary Rubio said, where he said that he was involved and the State Department was involved in revoking the green card, which is this odd language. But there is a ground of deportation. So all the grounds of deportation are laid out in 8 U.S.C. 1227, or what's also known as Section 237 of the Immigration Nationality Act. And this one says, and I'll just quote it, An alien whose presence or activities in the United States, the Secretary of State has reasonable ground to believe would have potentially serious adverse foreign policy consequences for the United States is deportable. So the way this gets triggered would be as follows. The Secretary of State, which is Marco Rubio, he was saying he triggered something, he would issue a proclamation that says that this individual, Mahmud, Khalil, or anybody else, their presence or activities in the United States would have serious adverse foreign policy consequences. That then becomes the ground of deportation. Then this person can be placed into deportation proceedings. Now, where this gets complicated is what happens next, because now this person goes to immigration court, and what happens? Does an immigration judge actually overrule Secretary Rubio's determination that this individual's presence has potentially serious adverse foreign policy consequences for the United States? This area of case law is very unclear. Also, when this individual then goes to court, they can normally get a review finally in the Court of Appeals. And the question would be, would the Court of Appeals make a determination that that's not true? So this is very sort of uncharted territory. This clause was meant in the past for people, let's say there was some dictator who was in some country making horrible murders and assassinations of people, and then they managed to find their way into the United States. And the question is, don't give refuge to this person because that's going to upset the rest of the world. And so the Secretary of State can say, we're not going to give refuge to this person. We're going to kick them out of the country because this would make the rest of the world very angry at us that we're giving refuge to this person. Here, it becomes a more complicated issue of trying to figure out why this particular student's presence in the United States actually tends to create adverse foreign policy consequences for the United States. That's a little bit tougher. There's an easier way to get at this issue, and it's unclear if they did, and if they didn't do it, why not, which would be to charge this individual under the category of deportation that just says, quote, endorses or espouses terrorist activity or persuades others to endorse or espouse terrorist activity or support a terrorist organization. And then in that case, if you have any sort of material or chants or quotes or anything else where this person is saying anything positive about Hamas and telling people, we need to support them in what they're doing or whatever, that clause seems to be an easier one. And then you'd have, again, the same debates in the immigration court whether he actually did this or not. But nevertheless, that seems like it would be more on target than this issue of having the Secretary of State say that these people on campuses are hurting U.S. foreign policy. That seems to be more difficult a fit than just charging them as people who endorse or espouse terrorist activity.
His wife's a U.S. citizen, so that's how he got the green card. She's expecting a child. Green card holders can be deported the same way that illegal immigrants can, or there's a higher standard?
So the problem is this. In the grounds of deportability, all of these grounds that we're talking about apply to all quote-unquote aliens. I know we all dislike this word, but an alien, by definition in the code, is someone who is not a U.S. citizen. So literally any person who's not a U.S. citizen, meaning even a lawful permanent resident, is potentially subject to this ground of deportation. And some grounds of deportation for lawful permanent residents have what are called waivers in them. What happens is you can try to deport someone, and you can even win. The charge can be sustained, but then the person can ask for a waiver, which means essentially saying, I'm sorry, can you forgive me for this? I won't do it again. And then the immigration judge would have the ability to grant a waiver. Here, there would be no waiver for this. So the defense of this person is either going to have to be that they don't fit within the charge themselves so that the charge cannot be sustained, or perhaps this person is from Syria, that deporting them to Syria at this moment might lead them to being tortured or something of this nature. But other than those two defenses, there's not going to be, unfortunately, a defense for this individual in the immigration court related to their spouse or their child in that situation.
Do we know what the charge against him is? Because apparently the Department of Homeland Security hasn't disclosed the legal basis for his detention.
Correct. That's not a nefarious thing. The Department of Homeland Security has not disclosed the legal basis for his detention, because the way it works is the document that you are given as a foreign national to be placing you into deportation proceedings, the notice to appear, is under the immigration law a confidential document that's governed by the Privacy Act, which means that the government can't release that document. It's not like an indictment. The only people who can release that document are Mahmud Khalil himself or his attorney in this situation. So that's not nefarious in that sense, that they're not saying why he is being detained, what he's being charged with. But the language of Secretary Rubio leads people to think that he's being charged under this doctrine that we will deport you if the Secretary of State has a reasonable ground to believe that your presence in the United States or your activities in the United States will potentially have serious adverse foreign policy consequences for the United States. So the idea would be that Secretary Rubio would have made this determination about this individual. That determination is then the predicate for the placement of the individual in detention, and now that's going to have to be fought out in court in a very rare, if almost non-existent, previous precedents about how this actually gets fought out. I mean, if the Secretary of State is saying that you are creating adverse foreign policy consequences for the United States, that's typically the kind of thing that gets extreme deference in the courts, such that how is it that, either an immigration judge or even a federal judge is going to basically say they're going to overturn such a determination? It seems quite complicated. But again, that would be one way. The other way would be to charge the person under the terrorist activity ground, which is very broad, and which one of them just says endorses or espouses terrorist activity or persuades others to endorse or espouse terrorist activity. That one would seem like the better fit. I don't know if that one was charged, if both were charged. You can charge more than one ground of deportation, but that's going to be what's going to have to be played out. And it would be actually quite helpful if Mr. Khalil or his attorney would release the notice to appear so that the public could know what the charge was, so that people could actually understand and have a common basis for having a discussion on whether what the government is doing makes sense or not.
Coming up next, why did the Department of Homeland Security ship Khalil 1,000 miles away? This is Bloomberg. Federal immigration enforcement agents arrested and detained Mahmud Khalil, a legal U.S. resident and Palestinian activist who played a prominent role in protests at Columbia last year. The White House press secretary said today the administration had moved to deport Khalil under a section of the Immigration and Nationality Act that gives the Secretary of State the power to deport a non-citizen if the government has reasonable ground to believe the person's presence could have serious adverse foreign policy consequences for the United States. I've been talking to Leon Fresco of Holland Knight. So, Leon, before the break, you were talking about how unusual, perhaps unprecedented, it is to use this section of the Immigration and Nationality Act to deport someone and how many constitutional questions it raises. One defense I've heard mentioned is that Khalil, he participated in protests in support of the Palestinian people in Gaza, not necessarily in support of Hamas.
Right. This is going to be the fact pattern that's going to need to be fleshed out in the courts, and the courts are going to have to decide. I will say this. There is a case, a very famous case in the 1950s called Harris-Iades versus the United States, which actually has quite a similar fact pattern in that it involved lawful permanent residents with U.S. citizen spouses and U.S. citizen children. And that involved communism and membership in the Communist Party. And the same allegations were being made. First Amendment, and also these people are lawful permanent residents, and they renounced their membership in the Communist Party. So what's the problem that they were communists? And that case went all the way to the Supreme Court, and the Supreme Court said, look, if Congress created this ground of deportation of membership in the Communist Party, then that's the ground of deportation. And it doesn't matter the First Amendment. It doesn't matter that you're a lawful permanent resident. It doesn't matter that you have U.S. citizen children. You're subject to that ground of deportation. It was a very close case, but that case remains good law in the United States, and it would be applicable here, meaning that the First Amendment in and of itself isn't going to be a defense. Really, the question is going to be one or the other, which is either if they charged him as a terrorist, did he engage in espousing any terrorist activities, or if they're charging him as a person whose presence will have potentially serious adverse foreign policy consequences. First of all, is that something an immigration judge is even going to have jurisdiction to review, or is that literally going to be deemed as something that's not reviewable? And what will ultimately the federal court say about that question? Because that is going to be quite an interesting question here, because obviously it's easier on the terrorist ground to say, well, what did someone say? What did someone do? But this is a sort of a second-order question. Is what the person is doing having potentially serious adverse foreign policy consequences for the United States? That has the potential to have such broad applications. These are the kinds of statutes that people know exist, but they don't get used because they're worried about the implications of using these statutes. And so that's going to be the issue moving forward, is where the courts are willing to go with regard to deference on these topics.
His lawyers didn't go to immigration court. They went to federal district court.
Yes. Here's what's interesting about that. This individual, the foreign national, was sitting in New York City, and they were detained. And then they were transferred first to a detention area in the Northeast, and then transferred to Louisiana. And so this is another of the fascinating issues of the immigration system that the courts really haven't grappled with. And this might be yet another case where they have to grapple with this issue too, is, okay, now that you're in Louisiana, what does that mean? You don't have access to the lawyer. And, if there is detention space in New York, why are you being sent to Louisiana? What circuit law is being applied to your case? And also, were you being sent there? Because here's what's also happened sometimes. And I'm not going to say one way or the other the motives or anything else. I'll just lay this out, which is you can go look on your own at the immigration court FOIA statistics that are put out every month, and they're done by Syracuse University. It's a program called TRAC, T-R-A-C. And they actually show a vast disparity in the rulings of judges. And so let's say you're in the immigration courts in New York or in San Francisco, you have a far, far, far greater chance of succeeding in your case than if you're in the immigration courts in Louisiana or in a detention facility in Georgia or something like that. And so the question is, first of all, is that a tactical thing that the government actually has at its disposal, which is that they could take someone and move them knowing this information? That's number one. And then number two, can they do that and then apply, let's say, Fifth Circuit case law now, which is in Louisiana, which is much more stringent in many different immigration cases, as opposed to Second Circuit case law, which is the case law that would have been applied in New York. And so part of this habeas was to say, bring this person back to New York so that they can actually have this fight in New York where the lawyer is and the case law and the judges and all of that. And that's going to be a very interesting question to see if Judge Furman, which is the judge who has jurisdiction of this in New York, he's issued a one-day stay of deportation. There wasn't going to be a deportation anyway, but he issued a one-day stay to sort of try to figure out all of this. Well, once he figures out all of this, what he's going to figure out is there is a massive panoply of constitutional issues in this case, almost dozens of them in just this one case. And he's probably going to say, wow, what do I do about this? This is quite an interesting imbroglio that's just stepped into my courts, including whether he even has jurisdiction to do any of this or has to wait until the whole process plays out, and then they can get to federal court. So there's a lot of questions here.
Khalil's lawyer said ICE's shell game of transferring him to Louisiana is a blatantly improper but familiar tactic designed to frustrate the New York federal court's jurisdiction and isolate Mahmud far from his lawyers, his home, and his local community of support, which is what you just said. There's a hearing on Wednesday. Can the judge order him to be brought to New York for the hearing?
So there's going to be two arguments that are going to be made at this
There's
hearing.
always more than one. Why is it?
Right. Correct. So the Department of Justice is going to say that none of these decisions can be made by a federal district court judge outside of the context of the removal proceedings, meaning this person has to go through the removal proceedings, get a result one way or the other. If they like the result, then good, end of story. If they don't like the result, they can make all of these 50 different claims that they're going to make, all to a court of appeals in what's called the petition for review of a final order removal. Query, would that be in the Fifth Circuit or would that be in the Second Circuit? That's its own complicated question that hasn't been decided by the court. So the lawyers for Mahmud Khalil are going to say, look, this needs to be decided independently of all of that, because what's happening is this is not part of the normal issues of immigration law, these issues of where someone is being detained, what jurisdiction they're being brought under, all of this. What good is a petition for review if at the end of the day it's in the wrong court in the first place and all of that? So they're going to try to say this is governed outside of the context of normal removal proceedings, and that's going to be up to Judge Furman to figure out what does he think. Should this all be confined within, let's say there's 50 constitutional arguments in this case. All of them need to go up to the Fifth Circuit at the end of this, and then maybe the Supreme Court? Or does he think, look, the fact that this case might even be in the Fifth Circuit is its own injustice that doesn't make it part of the removal process, and so I can come in and make these decisions because they're not even part of the removal process. This is actually a challenge to how the government operates its system, which is different than whether this individual gets deported or not. And so there are so many fascinating issues here.
But doesn't a habeas corpus petition allow the district judge to, bring the body into court?
Correct,
or is immigration law different?
Correct, but there is actually some very bad case law in 2022, I believe, or 2023 from the Supreme Court called Thurigasium versus the Department of Homeland Security. And I know I'm not doing that name a lot of justice, but where Justice Alito, who wrote the decision for the court, said that habeas is dead for immigration purposes. That habeas was a thing for the first 100 years of immigration law because the Congress hadn't created this whole structure that they've created now, where there's clearly ways and procedures and pathways. And so that those are the ones that have to be used, and there's not a separate thing called habeas for this. And so the question for Judge Furman is going to be, irrespective of Thurigasium, is there some exception that can be used for this type of case where there's all these debates about the forum and the government's use of transferring and what circuit and everything else, so that he can claim jurisdiction over this? And that's going to be a fascinating question.
A lot of fascinating questions are coming up in this case. And tomorrow, Judge Furman is holding a hearing, so we should find out more. Thanks so much, Leon. That's Leon Fresco of Holland Knight. President Trump has vowed to make additional arrests of pro-Palestinian demonstrators. In a briefing today, the White House press secretary said federal authorities have been using intelligence to identify other people involved in campus demonstrations critical of Israel that the administration considered to be anti-Semitic and pro-Hamas. Coming up next on the Bloomberg Law Show, Trump attacks another law firm and it fights back in court. I'm June Grasso and you're listening to Bloomberg. It's the second direct attack by President Donald Trump on a law firm. Trump signed an executive order last Thursday sanctioning one of the biggest law firms in the country, Perkins Coie, directing agencies to strip the firm's lawyers of security credentials, terminate federal contracts with the firm's clients, and bar its lawyers from entering government buildings. The order also directed the Equal Employment Opportunity Commission to investigate possible racial discrimination of leading law firms and accusing Perkins Coie of adopting race-based hiring quotas in 2019. Why was Perkins Coie targeted? The firm's lawyers advised Hillary Clinton and retained Washington firm Fusion GPS for the research that resulted in the so-called Steele dossier. It didn't take long for Perkins Coie to fire back, hiring Williams & Connolly, a firm known for its scorched-earth approach to taking on the Justice Department on behalf of clients, and today suing the Trump administration, claiming the executive order is unconstitutional and was intended to bully those who advocate for views opposite to the administration's. My guest is David Lopez, a professor at Rutgers Law School and the former General Counsel for the EEOC. David, what strikes you about this order targeting Perkins Coie?
I think the first thing that jumps out at anyone reading this is that it just seems like it's as much about political payback as anything, because I think the opening couple of paragraphs discuss, the 2016 election and refer to, and this is in the executive order, failed presidential candidate Hillary Clinton, and don't discuss DEI at all, right? And, I can't say that I've read every Trump executive order, and certainly can't say I've read every executive order ever written, but I don't think I've ever seen one that was so directed at any individual organization that is seemingly vilified as like a political enemy. And this one is, the fact that it's targeting one firm kind of jumps out at you. And then what's kind of odd, I would almost say even from a literary standpoint, is that then it moves on to DEI, right? It doesn't start in terms of talking about DEI, but then it sort of taps into the other executive orders addressing, the sort of opaque idea of DEI and the dangers of DEI to society. And so, it seems like it's a little bit of a forced connection here, but I think it's being used sort of as an opportunity, I think, to open up a new front on what I would certainly call a war on DEI at this point. I think it has to be viewed, certainly as much through a political lens as through any type of legal lens.
There seem to be so many legal arguments against this. Shall we start with First Amendment?
Yeah, I think obviously it has major First Amendment implications, but I think, the really important thing for listeners to understand is that a president can't change the law through executive fiat. And so everything that the president is doing is going to implicate, pre-existing statutes and the Constitution of the United States, right? So there may be a signal in the executive order that this is what they want to do and this is what they'll try to do. But, to the extent that it runs afoul of the Constitution and runs afoul of other statutes, there's going to be pushback. Perkins Coie has picked up Williams & Connolly, which is known to be a really kind of a hardball litigation law firm, to represent them in all of this. And I will say from my personal experience as General Counsel of the EEOC is that every time that we would sue a law firm, they would fight tooth and nail. Like this is not, because I think that basically, what litigators do is that they try to dispassionately assess the risks and they don't intimidate, right? And I think a lot of businesses in this age, as we've seen, are like, well, I don't want to be in the crosshairs, I don't want to be on the radar screen, and that they're pulling back what are often legal and necessary efforts to make sure that merit is a true factor in the workplace. But I think when you poke the bear of a law firm, I think it just puts you in a different situation, right? And I think we've seen with the executive orders time and time again is that there's been a lot of pushback, and a lot of it's been very successful, because I think these are as much political or ideologically driven documents as they are, I think, good faith efforts to execute the laws, which is what executive orders are usually designed to do. I think a lot of them have, certainly a propaganda purpose, But I think this one, in many respects, stands out just because it does basically declare Perkins Coie to be like a political enemy, and then it goes through a whole host of actions that they're going to take against this law firm, and then suddenly, connects it to DEI. I think if this were like a English creative writing course, this would probably flunk because I think there's a lot of thematic incongruities here. It almost reads like one of these like late night tweets or late night truth social posts that it was like kind of written at 3 a.m, when somebody couldn't sleep. I mean, that's really how it reads to me. And so we'll see. I mean, we'll see how it plays out. But I think the law firm has already signaled that, that there's going to be a pushback and that any effort, by the administration to violate First Amendment rights, to violate, their efforts to zealously represent their clients, their efforts to do business is going to be challenged.
This seems to be part of Trump's just war on the legal profession. Judges who don't rule for him, law firms who represent clients who go against him. And is it already having a chilling effect because reportedly some law firms turned down representing Perkins Coie?
Yeah, and I think that's a feature of many of these executive orders, which is sort of intimidation and self-censorship and self-restraint. I don't think that's sort of incidental. I think that's part of what's going on here, and it's not just going on obviously with the legal profession or with private businesses or with government. It also to a large extent has been directed at the press as well, and I think there's hope that that the press will. You see this sort of back and forth with the AP. On what seems to be like a pretty incidental and insignificant point. But, what you see is like really, I think, an effort to try to secure, self-censorship or self-restraint and to keep people from basically, speaking up, right, at a time when that's probably more important than it has been in a long time.
A lot of legal experts have said there are so many ways to attack this. It's patently unconstitutional. So tell us about an attack on the executive order based on due process claims.
The government can't basically take someone's, property interest or livelihood unless they provide some sort of due process protections, right? And, that's usually some adversarial adjudication, that allows basically the sharing of evidence and allows cross-examination of witnesses. Due process could mean many different things depending upon the context. But what it means is that you just can't go in and say, I'm taking over this business and I'm going to put you out of business because there's a property interest involved. And when the government does that, the Constitution requires, and the courts have said this, consistently, requires some protections for the party that's being impacted. That's part of what's going on here, right? Because clearly, I think anybody who reads this is going to see it as, this is basically an effort to ruin Perkins and Coie, right? And to make sure that people don't go to them and that they don't do good business, that they're not able to thrive as a law firm in a competitive market. And so I think that's the due process concern, right? Lawyers can be pretty zealous about their obligation to represent zealously their clients. And, and obviously, this is sort of a blowback against the representation of the Hillary Clinton campaign. And, again, it really smells of like political payback. I don't think there's any other way to read this.
It was said at the signing that the executive order calls for a holistic review of unlawful DEI in some of the nation's largest law firms. How would they even investigate that?
There are a couple things going on here, right? And so the president issued other DEI orders, and these orders have been enjoined, right? And so there's a district court in Maryland that enjoined one of the DEI orders, partly on First Amendment grounds, and said that the orders were drafted in an unconstitutionally vague manner, which, doesn't provide, sufficient guidance in terms of conduct. And I think it was that hearing, or maybe it was another one where, even the DOJ lawyers, and I don't want to fall into the trap and say the president's lawyers, but even the DOJ lawyers really couldn't define what DEI meant, right? So I think that there's certainly a real effort to keep that opaque, that kind of runs through this executive order as well. And I think that we've talked before about how, it's been unlawful since, 1964 to discriminate against a person based on race or based on gender, and that applies to all races and all genders. So to the extent that any white person believed that they were subject to discrimination, they've always had the right, and they have exercised that right to file discrimination claims and to prosecute those discrimination claims, and they're entitled to, certainly the same due process as any other litigant or any other complainant. So, so the president didn't change anything there. That's just sort of been the law of the land for a long time. I think the broad concern in terms of this sort of assault on DEI or this sort of stigmatization of DEI has really two components. One is that DEI, according to, many people who are practitioners, and that includes many, many, people in the legal profession, is really just designed to ensure merit, to ensure that you have a broad applicant pool, to ensure that as a company you go back and you look at your selection procedures and make sure that they don't exclude, people from any background and that they're related, most importantly, that they're related to the actual job, that you go back and you make sure that if there are any gender disparities in pay, that those gender disparities are justified for business reasons, right? In other words, that you go back and you make sure that your procedures, that your processes from recruitment to selection to promotion to retention, that they are all meritorious features, right? And so what is going on here is just sort of the most, in many ways, most remarkable gaslight imaginable, because one of the DEI executive orders talked about the restoration of merit, and it was focused on the federal government, which in many ways is the most merit-based, proceduralized part of the economy, right? The whole idea of the civil service is about ensuring merit, and it was designed basically as a reaction to hiring people just based on political favoritism, right? But what happened side by side with this, in plain sight, is that, there's been a real focus on, hey, we need to hire people throughout the government who are loyal to the president. And, loyalty is not a merit factor, right? Loyalty, this is exactly what the civil service protections were designed to prevent. This is exactly what DEI in its best form is designed to prevent, like the good old, old boys network. Let's just tap people, let's just tap our friends and just be really clubby and keep out the women and da-da-da. And so, this is all going on at the same time. And you really don't need to go beyond looking at the personnel choices that have been made at cabinet and sub-cabinet level positions, which certainly seem to run afoul of traditional criteria, from either replacing a well-decorated African-American who was head of the Joint Chief of Staff with someone of much more questionable qualifications. The only qualification is merit, right? You see this throughout the government. And so I think that's one thing that's going on. But I think, certainly as a law professor that works with younger people and worked with younger people who look like the United States of America, that is, they come from all different backgrounds, I think that this sort of weaponization of DEI as a slur has also had the impact, if not the intent, of having people question their own qualifications. And so, for those of us who work with people who are entering the job market, a lot of what we do is now pastoral in terms of, no, you've worked hard, you deserve this. But I think that's the fallout when you have a plane accident and the president comes out an hour later and say that this was a result of DEI. And then when asked, well, what is your basis for saying that? And he says common sense. So this has really, really broad impact, right? And I think folks need to understand that this is really an effort to make sure that employers have, almost like absolute unfettered discretion to make personnel decisions in every way. That means in this context, let's not be bothered by these pesky anti-discrimination laws, and let's, sort of explicitly say that, that loyalty is going to be a factor in our selections. But it also extends to organized labor, right? So you've seen concurrently, the president said, I'm not going to recognize the collective bargaining agreement with the TSA employees. Everyone knows that's a hard job, right? But, this is something that almost harkens back on President Reagan going to war with PATCO, right? It's really intended to send a signal along with other actions such as the dismissal of Gwen Wilcox, that organized labor is not going to be an impediment to the ability of employers to basically do as they will in the labor market.
Is his campaign against DEI working in a certain extent? Understand that, some law firms and companies are erasing any language like that in their websites, so that must mean that they're also erasing their efforts in that area.
Yeah, I think there's a conversation in the field of whether people are going to continue to do work under a different name. But I think certainly, if you look at companies such as, Meta or Amazon, it seems to be like a wholesale retreat in this area. So, I think to the extent that you see that, it's something that, has been working with, I think, some really, big name employers. Target is another one. I think to a certain extent it has been working. But I think it's important to say, as someone who's now an academic, certainly there's a lot of good faith differences about issues of affirmative action, right? And about, issues of the importance of voice and diversity in the workplace or in an academic institution. And, the courts have been duking it out with a lot of 5-4 decisions for a long time. But I think it's really super important to remember that there's also a long history of using anxiety about preferences, particularly racial preferences, as sort of a wellspring for political activity. So, even if you go back to the 19th century, one of the most famous cases, gutting Reconstruction, the justice who wrote it, the civil rights cases, is basically there comes a time when African Americans need to walk on their own. They need to cease being the special favorite of the state, right? This is just 15 years after the end of slavery. And then politically, we've seen this for a long time. This is part of the famous Nixon Southern strategy, right? This is I don't know if you remember the Jesse Helms ad, where he shows some white hands. He's running against Harvey Gantt, the former African-American mayor of Charlotte, very close election. And he has these white hands. The voiceover is, you wanted the job, you needed the job, but you didn't get the job because of a racial quota. And then at the same time, you had a lot of politicization of the effort to codify disparate impact. And, George Bush famously is like, I'm not going to sign the Quota Act. And then you have, in the Republican platform, quotas are the most pernicious form of discrimination. And so, certainly in the race area, this is an old playbook. This is not new. I think this is more than sort of a good faith belief in formal equality. This is also basically a dog whistle, not so subtle dog whistle to the base, because, this is sort of building on a long history of using anxieties over racial preferences for African Americans as a way to sort of whip up political support. And I just think that's sad, because I think that operates against a backdrop where, we have more inequality in the economy than we've ever seen. And it operates against, the backdrop of Elon Musk, sort of whipping through the federal government and, just cutting things. He's the ultimate, bad boss. Tell me 5 things that you've done. I want to write a column called Glenn Musk, because he's worse than Alec Baldwin. It's you're going to do it, I don't care. And, we've all had the boss, that doesn't know anything about what you do, but still undervalues it, right? Or just is basically I'm the smartest person in the room, and everyone's like, you have no clue what I do, right? You're just looking at boxes, and you're just eliminating boxes. And so, that's going on. And, right now, there's a lot of, I think, good faith belief that Medicaid is in peril. And so, people are talking about, DEI. It becomes almost like a distraction at this point, because that's not what has left wages stagnant. And that's not what has created all this inequality in our economy. It isn't DEI, right? DEI becomes like a distraction there. But I think that, a lot of the anxieties that working people feel, and just to say, hey, a lot of the issues that become these cultural flashpoints deliberately are often designed to make you not look in the other direction at what's going on over here. The good old Wizard of Oz.
Will this be a very slow process to untangle all these things that in his executive order against Perkins Coie?
Well, I think what you've seen is that just a lot of the executive orders have been enjoined, so it may not be a slow process at all. You can call me again when briefs start flying, and I imagine that's going to be very soon. There's a real effort to kind of move quickly on a lot of things in a lot of areas, but that becomes like a double-edged sword for the administration, because what happens is that things are often sloppily done and easily struck down. But I think what also happens, and I'm going to just say this as someone who is very proud of my service at the Department of Justice and being able to stand up and say, I represent the United States of America. When I was there, I was very frustrated sometimes because I'm like, DOJ is so bureaucratic and cumbersome and cautious, right? And when I was at the EEOC, it's like, DOJ so, bureaucratic, cumbersome, and cautious. But they do that to maintain the institutional credibility of the institution. And it's really built into the DNA of the lifers who have worked at DOJ that, hey, we represent the United States. We're not like the private consigliaries of the president. We represent the United States. And as administrations change, we always have to maintain the credibility of the institution as lawyers with the courts, right? That is so built into the DNA of the Department of Justice. And it feels like that's unraveled in 1 month. It's just sort of like we're going to go there and we're going to say anything, and then they keep getting kind of slapped down by the courts. Then you see people who are leaving en masse because they understand what's happening, and they don't want to be part of it. And often the last form of resistance that many people have is to sort of walk out with their feet. But it really hurts the credibility of the Department of Justice. Hopefully they'll be able to kind of one day claw that back. But to send lawyers in to represent something like this or like some of the other executive orders doesn't really help with the stature of the nation's lawyers.
We're going to have to leave it there. Thanks so much, David. That's Professor David Lopez of Rutgers Law School. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.